Welcome to the Deep Dive. Today we're really digging into a major global challenge for you. It's
Yeah,
this huge growing demand for critical minerals. The ones we need for the clean energy transition, driven by things like the Paris Agreement.
absolutely. But there's a real tension there, isn't there? Because getting those minerals, it often comes with significant environmental and social costs that are usually felt most sharply right in the regions where the digging happens.
Exactly. And there are attempts to manage this, right? Like those 2024 guiding principles on critical energy transition minerals.
Yes, that's a key development. They really try to put human rights right at the core. That's principle one. And principle two is all about safeguarding the planet. So setting a standard, you could say.
Okay, principles are one thing, but let's make it concrete. Let's talk about Zambia, February 2025, the Kafue River spill.
A really stark example. You had a tailings dam collapse at the Sino copper mine. Acidic waste just pouring into the river's tributaries.
Horrific. And the Kafue isn't just any river, is it? It's massive, supports millions of people.
Precisely. And the immediate fallout was devastating. Fish kills, wildlife deaths, crops ruined, and critically, it disrupted the water supply for the people in Kidwe.
So it really throws up this huge question for us, and for you listening. Are the legal responses we see, especially in places like Zambia, actually enough? They seem focused on compensating people after disaster strikes. But what about the sheer environmental destruction, the damage to the river itself?
That's the core issue. Zambia's main environmental law, the Environmental Management Act from 2011, it recognizes the right to a clean environment. Section 4, but it frames it very much in terms of human rights. Anthropocentric, we call it, focused on people.
Right, focused on us, which is interesting when you compare it to, say, Uganda. Their 2019 National Environment Act talks about the rights of nature, gives nature rights like the right to exist, persist, maintain, and revitalize.
Completely different angle. Ecocentric,
Yeah.
focused on the ecosystem itself.
Exactly. So could this rights of nature idea hold potential for Zambia, especially after something like the Kafue spill? That's what we're exploring for you today. Is compensation for human harm really the full picture?
Let's start with what actually happened legally after the Kafue spill. There was action taken pretty quickly. A company called Panthera Ventures Limited sued Sino
Okay, where did they file?
in the Lusaka High Court. And they asked for specific things. They wanted Sino to stop polluting operations immediately, to halt activities at the damaged tailings facility until it was properly fixed.
What else?
They also wanted better air pollution controls installed and, crucially, compensation for the farmers and property owners whose livelihoods were hit.
So that sounds like it's working within Zambia's existing laws, environmental regulations, maybe tort law principles, trying to get immediate help for the affected people.
That's right. It's about redress for the communities. And we also saw the government step in.
Yeah, they shut down the plant, didn't they?
They did. Shut down Sino and ordered them to carry out environmental restoration work.
Okay, so this response, focusing on stopping the pollution and compensating people, it feels familiar somehow. Have we seen this pattern before in the region?
We have. You might remember the Vedanta Resources case back in 2019. Pollution from the Nchanga copper mine, also in Zambia.
Ah, yes. That involved a lot of claimants, didn't it?
Nearly 2,000 Zambians. And they took their case all the way to the UK High Court.
Why the UK?
Because Vedanta's parent company is based there, and the UK Supreme Court actually set a really important precedent. They ruled that a parent company in the UK can potentially be held liable for harm caused by its subsidiary overseas. It depends on their duty of care, potential negligence.
That sounds like a big step for accountability.
It was in terms of cross-border liability. But here's the key thing. Just like the current Sino case seems to be shaping up, the Vedanta case still focused primarily on the human harm, health problems, loss of farming income.
Right. The river itself wasn't like a plaintiff. It wasn't seen as having its own rights that were violated.
Exactly. And that Vedanta case, it ended with an out-of-court settlement, no admission of liability from the company.
And there was another case too, Yasulu.
Yes. Nyasulu versus Kampola Copper Mines, another Zambian case, Lusaka High Court again. KCM was ordered to pay about US $2 million for discharging toxic waste into the Mushima River.
And again, the focus was?
Human health and livelihoods, not the ecological damage to the river as a separate issue.
So this pattern of focusing on human compensation seems pretty established in Zambia's legal approach.
It does, which makes the fact that the Sino case is being pursued domestically in Zambian courts quite interesting.
What do you mean?
Well, on one hand, maybe it shows confidence in the local judiciary to handle these complex environmental cases.
But on the other hand,
On the other hand, the defendant, Sinometals, is a state-owned enterprise from China. That adds another layer of complexity.
how so? Is accountability different compared to, say, the UK system we saw with Vedanta?
It appears to be quite different. There isn't really a well-trodden legal path for foreign communities to sue Chinese state-owned enterprises in Chinese courts for environmental damage caused abroad, not like the tort law system in the UK.
So even though China might help with cleanup, like they apparently offered to do?
Right, that assistance doesn't equate to legal liability established through a court judgment. There's a lack of clear precedent or framework for that kind of cross-border tort claim against Chinese entities in this specific context.
That's really limits the options for affected communities, perhaps.
Right.
It pushes the focus back onto the Zambian system and its existing framework.
Precisely. And it forces us to think about what kinds of harm our legal systems are currently set up to even recognize and deal with.
And all of this specific incident, it's happening while the global demand for these critical minerals is just skyrocketing.
Absolutely. The clean energy transition needs copper, cobalt, lithium, the very things being mined. And if you look at the bigger picture, the environmental load, the burden of extracting these minerals, it often falls hardest on developing countries.
Countries that might already be struggling with the impacts of climate change.
Exactly. So you risk this cycle. Ecological damage, water contamination, communities displaced, all in the name of a global green transition whose benefits might not be felt equally.
A difficult paradox. So the goal is sustainability, but the process itself can be incredibly damaging locally. What's happening internationally to address this? Are there broader legal shifts?
Well, there's definitely growing recognition internationally that human rights and environmental harm from mining are deeply linked. You have the UN Guiding Principles on Business and Human Rights from 2011. They're quite clear. Businesses, including the big transnational ones, have a responsibility to respect human rights.
And that includes environmental impacts.
Yes. Doing due diligence, assessing social and environmental impacts, that's part of it.
What about regional frameworks? Africa, for instance.
The African Charter on Human and People's Rights is important here. Article 24 guarantees the right to a satisfactory environment, and the Sirek versus Nigeria case before the African Commission was huge.
Remind me what that established.
It found Nigeria had violated the charter by failing to prevent oil companies from causing severe environmental damage. And importantly, it clarified that multinational corporations operating in a country have this heightened responsibility to prevent harm both to people and the environment.
Okay, so principles and regional rulings exist. What about more concrete global actions? I've heard talk about panels on critical minerals, maybe a global fund.
Yes, the UN Secretary General set up a panel specifically on critical energy transition minerals. And there's been discussion about a global mining legacy fund to deal with old abandoned mines.
And that UN treaty on business and human rights. Is that moving forward?
It's trying to. The goal is to create binding international rules to hold corporations accountable for abuses. But progress has been, well, let's say slow. Lots of political hurdles.
So while treaty law develops slowly, are other ideas gaining traction?
Interestingly, yes. Even bodies like the OECD are starting to talk about the need for something like a rights of nature approach in places where minerals are extracted, recognizing nature's own value, not just its use to us.
And the UN?
The UN General Assembly has its Harmony with Nature initiative, pushing for more Earth-centered thinking and governance.
It feels like a shift is happening, at least in international discourse. You mentioned the Inter-American Court of Human Rights recognizing rights of nature, too.
That's right, which really contrasts sharply with how many domestic legal systems, like Zambia's, still operate treating nature fundamentally as property to be managed or exploited, albeit with some regulations.
Which brings us back to that core question. How do legal systems actually start recognizing ecological harm beyond just its impact on human interests?
And that leads us directly to this idea of rights of nature, or RON, granting legal personhood to nature.
Legal personhood, like a company.
Sort of, yeah. The idea is to give natural entities, rivers, forests, mountains, actual legal standing, rights. So they can be represented in court, their interests defended, not just because humans are harmed, but because the river itself has a right to be healthy, to flow, to exist.
So someone could sue on behalf of the river.
Essentially, yes. Guardians could be appointed to act in the river's best interests, pushing for protection and restoration, even preventing harm before it happens. It shifts the focus.
Where has this actually been tried? You mentioned some examples earlier.
New Zealand is probably the most famous case with the Wanganui River. It was granted legal personhood, reflecting its deep spiritual importance to the Maori people, but also its ecological significance.
Any others?
India had a lower court ruling granting rights to the Ganges and Yamuna rivers. That's currently stayed by their Supreme Court, facing legal challenges, but it shows the idea is being tested.
It feels particularly relevant for mining, doesn't it?
Yeah.
Because the damage can be so profound and long-lasting.
Exactly. We're not just talking about immediate pollution that can maybe be cleaned up. Mining can cause biodiversity loss, land degradation, deforestation, things that might be irreversible.
Things that harm the ecosystem itself, regardless of immediate human impact.
Precisely. So, Enron framework could potentially act more proactively. It says nature has fundamental rights that need to be respected before damage occurs, not just compensated after.
How does this compare to Zambia's current laws? You said they have environmental protections.
They do in the Constitution and the Environmental Management Act. But enforcement often seems geared towards making sure companies tick the right administrative boxes, follow the rules. It's less focused on deep ecological restoration or fundamentally recognizing nature's own interests.
And that gap matters.
It really matters, especially when you think about controversial proposals like the Kangaloo Mine project, which was planned inside the Lower Zambezi National Park, a supposedly protected area. And Ron approach might frame that debate very differently.
You also brought up Colombia and Ecuador as places using RON in response to extraction. What can we learn there?
Colombia's constitutional court ruling on the Atrato River is fascinating. They explicitly recognized the river as a legal subject with rights. This was directly because of terrible environmental damage from illegal gold mining. The court shifted from a human-centered view to an ecocentric one, saying the river itself deserved protection.
And Ecuador, they went even further, right?
They did. Ecuador put rights of nature right into their constitution back in 2008, again, largely driven by concerns about oil drilling and mining in the Amazon. And it's not just symbolic. In 2021, their constitutional court used those RON provisions to actually stop a mining project in the Las Cedras protected forest.
Wow. So real legal teeth.
Exactly. These examples show RON isn't just theoretical. It can be a practical legal tool. And they offer, I think, really valuable lessons for a country like Zambia grappling with the impacts of its own mining sector.
So back to the Kafue River. Sino Metals has apparently agreed to clean up and compensate communities. That sounds positive, doesn't it?
It is positive, certainly, that there is acknowledgement of harm and a commitment to remediation and compensation. But
is it enough for the long term? Is that what you're suggesting?
it raises the question, yes. Is compensating for human losses, while vital, sufficient to prevent future disasters or address the deep ecological wounds? The current Zambian approach, being anthropocentric, arguably allows environmental harm as long as the human damages are eventually paid for.
Which might ignore harm to the ecosystem that doesn't directly translate into a monetary loss for a person or community right now.
Exactly. Recognizing the rights of nature could fundamentally change that calculus. It would make the river, the ecosystem, a stakeholder in its own right. Its health and survival would have legal weight, forcing a consideration of ecological well-being alongside human economic interests in mining decisions. It's potentially a systemic shift.
And we can't ignore the backdrop to all this, to geopolitics.
Definitely not. Chinese companies play a huge role in Zambia's mining sector, as we noted, and they're involved in many other big development projects, too.
Like infrastructure.
Yes. Just recently, formal agreements were signed for Chinese funding to help redevelop Zambia's railways, plus emergency food aid, a technology grant.
So there are deep and growing economic ties.
Absolutely. And those complex relationships inevitably intersect with how issues like environmental damage and corporate accountability are handled. It's all interconnected.
Okay, so let's try and pull this together. We've been looking at this intense conflict. On one side, this urgent global push for critical minerals, essential for, a greener future.
And on the other side, the harsh environmental realities of getting those minerals out of the ground, vividly shown by the Kafue River spill in Zambia.
And we've seen that the current legal response in Zambia, while focused on helping affected people, is primarily human-centered.
Right, which means it might struggle to fully account for or prevent the sheer ecological destruction these incidents can cause.
Which is where the idea of rights of nature comes in. Not necessarily replacing the human rights focus, but complementing it.
Exactly. Offering perhaps a stronger, more lasting foundation to protect ecosystems and the communities who depend on them. moving beyond just paying for damage after the fact.
So here's something for you, our listener, to really chew on. As these environmental challenges linked to the green transition become more frequent, more intense, how do our legal systems globally need to change?
How can we genuinely start protecting the planet by recognizing the intrinsic value of nature, not just its value to us?
And what role can nations like Zambia play? Could they be pioneers in shifting how we think about environmental law and protection?
Now, for those of you preparing for the UPSC exams, this discussion really hits on several key areas. You've got environmental law, international relations, sustainable development challenges, corporate accountability.
All incredibly relevant for mains and potentially prelims, too. Understanding these interconnected issues, the legal frameworks, the international context, it's crucial. So we hope this deep dive has given you valuable insights.
Definitely. And if you found this helpful or it sparked some thoughts, please do like this, subscribe to our channel, and leave us a comment. We'd love to hear your questions or perspectives on this really important topic.
And just to mention, our discussion today drew heavily on the excellent analysis over at EJIL Talk, a great resource if you want to explore further.